You're about to make a decision that could leave your family with nothing. The government has a default plan for your money, and I promise you, it is not the plan you would choose. Think about that for a moment. You've worked a lifetime. You've paid your taxes. You've saved. You've sacrificed. And you're probably thinking, my family knows what I want. We've talked about it. My kids will figure it out. That is the most dangerous assumption you can make. I'm here to tell you about a mistake that is made every single day by people just like you. It is the single most costly error in estate planning, and it doesn't just cost money. It costs time, it causes stress, and it can tear a family apart. I'm going to break this down in plain, simple English so you can protect the people you love. Let's start with the basics. When you pass away, everything you own, your house, your bank accounts, your investments, is called your estate. If you have a plan, a will, or a trust, that document tells the court what to do with your property. If you don't have a plan, the state has a plan for you. That is a simple fact of law. This default plan is called intestacy. It's a fancy legal word that essentially means the government decides who gets your stuff. Now, the state's formula is cold and impersonal. It typically favors a spouse first, then children, then parents. But here's the catch. The law doesn't know that you wanted to leave your classic car to your grandson. It doesn't know that you wanted to make sure your daughter-in-law was taken care of. It doesn't know about the promise you made to your sister. It just follows a rigid formula based on bloodlines. And I can tell you from experience, state law rarely matches a person's actual wishes. Imagine this scenario. A man loses his wife, he's devastated. He remarries a wonderful woman a few years later. They live happily for another decade. They own a home together. He passes away without updating his will. Under the law in many states, his new wife doesn't automatically inherit everything. The property might be split between the new wife and the children from his first marriage. Now you have a grieving widow who has to go to court against her stepchildren over who gets the house. It is a nightmare scenario, and it happens all the time. That is the first layer of this mistake. It leaves everything up to chance and the courts. But the mistake goes much deeper. It involves a piece of paper that is more powerful than any will you can write. I'm talking about the beneficiary designation. You see, a will controls assets that are in your name alone. But a beneficiary designation, that's the form you fill out for your IRA, your 401k, or your life insurance, overrides your will. That is a critical piece of information. The money in these accounts goes directly to the person you named on the form, regardless of what your will says. Here's a common example. A gentleman gets divorced. He remarries. He updates his will to leave everything to his new wife and his children. But he forgets to update the beneficiary form on his old 401k from his job. He passes away. The new wife and children go to the bank, expecting to manage the account. The bank pulls up the old form. The money goes to his ex-wife. It is a devastating blow, and by the time the family finds out, it is too late. The financial institution is legally required to pay the money to the named beneficiary. They don't care about the will. They don't care about a letter you wrote to your kids. They care about that one piece of paper you signed 15 years ago. Now, let me tell you what happens if you don't name a beneficiary at all. This is another variation of the mistake. You might think, if I don't name anyone, it just goes to my estate and then my family gets it. That is true, but this is where it gets expensive. When a retirement account goes to your estate, it is forced into a court process called probate. Probate is a public, time-consuming, and expensive process. The court has to validate your will, pay your debts, and then distribute your assets. But for a retirement account, the tax rules are brutal. If your IRA or 401k goes to your estate, the estate must empty that account within just 5 years, and the tax bracket for an estate is incredibly compressed. The estate hits the highest tax bracket at a much, much lower level of income than you do as an individual. So, a huge chunk of your life savings gets eaten up by the IRS, leaving less for your family. This is exactly why a financial professional will tell you that the estate is the worst beneficiary you can ever have for a retirement account. By not naming a person, you are handing your money over to a legal process that is designed to protect the interests of the court and the IRS, not your family. Let's look at another variation of this costly error that I see far too often. Many seniors are told by a well-meaning friend or bank teller to just put your daughter's name on the account so she can pay your bills. On the surface, it sounds like a smart and helpful thing to do. They want to help you and you want to make things easier for them. But this is a dangerous game of legal roulette. When you add your child's name to your bank account, you are typically creating a joint account with a right of survivorship. What this means is that upon your death, that bank account is no longer yours. It automatically becomes your daughter's. It bypasses your will entirely. It is hers, and she can do whatever she wants with it. Now, if your intention was to leave that money specifically to your daughter, then you've accomplished your goal. But what if you added her just for convenience? What if you wanted to split that money equally between your 3 children? If that account has $100,000 in it, and you named your daughter as joint owner, that $100,000 belongs to her. Your other 2 children get nothing. You can have a will that says split everything equally, but that bank account will not follow that instruction. This creates a massive conflict. It pits your children against each other at a time when they are already grieving. They are forced to go to court. They need lawyers. It can take years to resolve, and the court costs eat into the very money you were trying to leave them. I have seen this play out in courtrooms across the country for over 28 years. It's a legacy of heartbreak and legal bills that no parent ever intends to leave. How do you avoid this? The solution is deceptively simple. You need to coordinate your estate plan with your beneficiary designations. You need to make sure that the forms you signed for your IRA and your 401k align with the wishes you expressed in your will. You cannot treat these as separate documents. They must be part of one unified plan. That means, first, you need to make sure you have a valid will or trust. And I'm not talking about a do-it-yourself form you found on the internet. I have a simple rule of thumb that has guided my advice for decades. A good estate plan is not the place to cut corners. Think of it this way. You would never let a mechanic perform heart surgery. In the same way, you shouldn't trust your family's future to a generic online template. The laws are complex. They change often. A qualified attorney provides you with peace of mind and guidance, not just documents. Once you have that plan, you need a professional to help you review every single one of your beneficiary forms. You need to check your IRA, your life insurance policies, your annuities, and any other assets that have a named beneficiary. You should do this at least every few years. You should definitely do it after any major life event like a marriage, a divorce, the birth of a grandchild, or the death of a loved one. To prevent this mistake from leaving your family with nothing, you need to understand that estate planning is not about documents sitting in a safe. It is about people. It is about the relationships you have built over a lifetime. It is about protecting the ones you love from a system that can be cold, expensive, and unforgiving. We've covered a lot of ground today, but I want you to remember one thing more than anything else. The number one mistake is inaction, thinking you have more time, procrastinating until it is too late. My encouragement to you is this: make the call this week. Talk to a professional. If you have a plan, pull it out and read it. If you haven't updated it in 5 years, it needs to be reviewed. This is the most loving thing you can do for your family. It is a gift that goes beyond money. It is the gift of clarity and peace. If you found this information helpful and want to avoid other costly retirement mistakes, please hit the like button on this video. We are dedicated to providing you with the straightforward financial advice you need to navigate your retirement years. Subscribe to the channel and turn on the notification bell so you never miss an update. And please, leave a comment below. Have you or someone you know ever dealt with an estate planning issue like this? Your story could help someone else avoid the same heartbreak. Thank you for watching.